Hey guys, welcome to my legal classes. This is Ganesh Pujari, and as far as judgment is concerned, this is my second video. In my previous video, we have covered two important sections from chapter 27 of CRPC, that is section number 353 and 354. In this session, I am going to cover three important sections starting from 355, 356 and 357. As I have already briefed, chapter 27 of CRPC has total 13 sections on judgment starting from section 353 to 365. Why to waste time? Let's get into section number 355. Section 355 is very easy, which covers the particulars that are need to be covered by a metropolitan magistrate. What are the particulars to be covered? The serial number of the case, the date of the commission of the offense, the name of the complainant, the name of the accused person, his parents' details and residence, the offense complained or proved, the plea of the accused and his examination, the final order, the date of such order, and if there are any opportunity given to make appeal under section 373 or 374 subclause 3, the reason for the same needs to be given. What is 373? Appeal from orders requiring security and refusal to accept or rejecting surety for keeping peace or good behavior, and 374 subclause 3 discusses about appeals from convictions and other details. Then comes section 356, which is very important as far as the previously convicted offenders are concerned. Now there are 6 subclauses and I am going to discuss subclause 1 with the help of an illustration. Imagine there is one Mr. A and he has already been convicted once under the IPC section maybe of 215 or 489 A, B, C or D, or under section 506 or under chapter 12 or under chapter 17. Now the punishment was more than 3 years and this punishment was given by Indian court. That is one of the necessary important requirement. And then if he is getting convicted under any of these sections again, in that case, along with the imprisonment, the court can also ask him to give maximum of 5 years. The details like where he is going to reside, or any time when he is changing the residence, he need to give the information, or if he is going to be absent from that particular residence, that information can also be asked on the basis of court requirement. Like it is the decision of court whether to ask or not, but that is available as per section 356 subclause 1. So the key informations that you need to remember is the person is being convicted by a court of India already under IPC section maybe 215, 489A, B, C or D, section 506 or chapter 12 or chapter 17. And what is the punishment? Punishment should be of more than 3 years and he got convicted again. Now while giving the punishment along with imprisonment, after his imprisonment is complete, the court can ask the details of his residence, or whenever he is changing the residence, that details, or if he is going to be absent from that residence, that details. All of this information can be asked by the court and the time duration is maximum 5 years after the release. I hope that is very clear. With that, I am getting into other subclauses from this particular section. The other subclauses are easy, but remember it is not required to commit the offences as per the IPC list I have given in the previous page. If even you are doing a criminal conspiracy or abatement of such offences, that itself is sufficient to ask for the address details in the second time conviction. That is very important. If there is opportunity for appeal, and in the appeal if he is proven to be like not guilty, in that case everything which is discussed under 356 comes to void and the court cannot ask to notify the address and other stuff. And who can make order under this particular section? The appellate court, high court or the court of session can ask for the details, and the state government has the power to make rules under this particular section. These are the important points that you need to remember as far as section 356 is concerned. Then comes section 357, which discusses about order to pay compensation. In certain cases, there will be compensation given to the victim or the victim's party. Now this provision is very interesting, but while I go through subclauses, you need to be little attentive. Now for example, subclause 1 and subclause 3 are discussing two different aspects. So I am asking you to give fullest focus so that you get all the points clearly. Subclause 1 discusses about all those sentences which has fine as part of the punishment. Now he may have got some imprisonment or may not be. Now he might have got 3 years imprisonment, 10 years imprisonment or life imprisonment or maybe death punishment whatsoever. But if the other part of sentence is fine, then the judgment can say that the whole or any part of such fine recovered can be utilized for 4 different purposes. What are the purposes? It can be utilized as an expense incurred in the prosecution, or it may be paid as compensation to the victim, or if there is any death or abatement of such commission under Fatal Accident Act 1855, in that case, to the person who is impacted by that death will get that as compensation, or in the act of any theft, criminal misappropriation or criminal breach of trust or cheating, etc. Now the person who is buying, if he is a bona fide purchaser, like he doesn't know that whatever he is buying is coming in the form of theft or cheating or something like that, he is not aware but he is buying, in that case we are calling him as bona fide purchaser. And if bona fide purchaser has purchased, in that case the fine whatever is recovered can be utilized for compensating such bona fide purchaser also. These are the 4 provisions discussed under subclause 1. Subclause 2 is again interesting. What if there is an opportunity to appeal? Now the judgment has come and the fine is part of the punishment, and it is also decided that a certain part of the fine or the whole of the fine should be utilized for so and so purpose, and then there is an opportunity to appeal. In that case, can we collect the fine or should we wait? That is what discussed under subclause 2. It says no fine shall be collected till the time decision has come from such appeal or lapse of time for such appeal. So we need to keep 2 important things in our mind. One, if the appeal has gone, then we have to wait to collect the fine till the time the final decision has come. Or if there is an opportunity for appeal but nobody has appealed and then lapse of time happened, in that case the provision for collecting the fine is available. So we need to wait till the time the final decision has come after the appeal, or if the appeal has not made within the time period. In that case, only after that has happened we can collect the fine. That is what you need to remember. Now comes the beauty of this particular section, subclause 3. What happened in subclause 1? It is discussing about the provision where sentence includes fine as a part of the punishment. What if fine is not part of the punishment? Can we still have compensation? That is what precisely discussed under subclause 3. Now here, fine is not part of the sentence. However, the judgment can ask the accused to pay compensation to the victim for the loss or injury which happened because of the act of the accused. So that's very clear. Subclause 3 says even if fine is not part of the punishment, the court still can ask the accused to pay the compensation to the victim. That is what you need to remember, which is very important aspect. Subclause 4 discusses about who can make the order. The order can be made by the appellate court, high court or the court of session. Any of these court can make the order. And the 5th one is again very interesting. If civil suit is raised subsequently on the same issue after awarding compensation, what happens? In that case, civil court shall take into account any sum paid or recovered under this section. So while dealing such civil suits, the civil court should observe the section 357 because it is going subsequent to the judgment which came under this particular section. That is very important. With that much information, I am concluding my session on this particular aspect. But remember, this is not an end as far as the section 357 is concerned. I am going to make one independent video on section 357 A, B and C, which are basically discussing about victim compensation scheme, which are the results of the criminal law amendment of the year 2013 and 2018. That will be a very important presentation when you are practicing also. And then as far as compensations is concerned, there are two more sections, that is section 358 and 359. 358 discusses about compensation to persons arrested without grounds, and 359 discusses about payment of cost in non-cognizable offenses. I am going to discuss these two aspects also in my future videos. I enjoyed covering these three sections, section 355, 56 and 357. These are few very important sections, so you need to go section by section. It is not that how exactly you are just going to answer in your exam. You being an advocate, tomorrow if you are getting into this situation, how exactly you are going to apply these sections is very important. That is why I am discussing every single subclause also in detail. I hope that helps you. Please subscribe my channel, please like, share and comment my videos. All the very best for whatsoever purpose you are watching my channel, and thanks again.